In the previous section, we explored the redemption periods that apply to various foreclosure types in Arizona, distinguishing between judicial and non-judicial processes. Building on that foundation, we now examine the deed of trust foreclosure, which is the most common foreclosure method in Arizona, governed by ARS, Chapter 6.1, paragraph 33, 801 through paragraph 33, 821. This process allows lenders to foreclose on defaulted loans without court involvement, making it faster and less costly than judicial foreclosure. A deed of trust is a three-party security instrument involving the trustor, borrower, beneficiary, lender, and trustee, a neutral third party. The trustor conveys legal title to the trustee as security for the loan. If the borrower defaults, the trustee, acting on behalf of the beneficiary, has the authority to sell the property through a trustee's sale, a non-judicial foreclosure process. Once the sale is completed, the buyer receives a trustee's deed upon sale, transferring ownership free of the borrower's redemption rights. The process begins when the borrower fails to make payments or violates another condition of the loan agreement, such as failing to pay property taxes or maintain insurance. The lender, after confirming the default, instructs the trustee to initiate foreclosure proceedings. Under ARS, paragraph 33, 808, the trustee must prepare and record a notice of trustee's sale in the county where the property is located. This notice serves as public record that foreclosure proceedings have begun. The notice of trustee's sale must be recorded at least 91 days before the sale date, and copies must be mailed to all interested parties, including the borrower, junior lien holders, and anyone who has recorded an interest in the property. Additionally, the notice must be published in a local newspaper once a week for 4 consecutive weeks and posted conspicuously on the property itself and at the county courthouse. This comprehensive notice ensures transparency and gives all parties a fair opportunity to respond or redeem. Once the notice is recorded, the borrower has until the day before the sale to reinstate the loan by paying the amount in default, plus late fees, trustees' fees, and costs under ARS, paragraph 33, 803. This is known as the reinstatement right, the borrower's last chance to cure the default and prevent the sale. However, once the sale occurs, the borrower's rights are terminated, and title passes immediately to the winning bidder. On the scheduled date, the trustee conducts a public auction at the time and place specified in the notice. The property is sold to the highest cash bidder, often the lender if no other bidders appear. The trustee then issues a trustee's deed upon sale to the purchaser, which transfers ownership and extinguishes any subordinate liens or interests. Because Arizona's process is non-judicial, the sale is final once completed, and there is no post-sale redemption period. For example, consider a borrower in Chandler who defaults on their mortgage. The trustee records the notice of trustee's sale, publishes it in the local newspaper, and mails copies to all parties with recorded interests. 91 days later, the property is auctioned. If the borrower pays the arrears before the auction, the sale is canceled. If not, the property transfers to the highest bidder, usually the lender, and the borrower's ownership ends immediately. It is important to understand that while a deed of trust foreclosure is more efficient, it must follow strict statutory requirements. Failure to comply with notice or timing provisions can invalidate the sale. In Patton v. First Federal Savings and Loan Association, 1978, the Arizona Supreme Court held that trustees must strictly adhere to statutory procedures to protect the borrower's due process rights. Any deviation, such as failing to give proper notice, can render the foreclosure void. Additionally, once the trustee's sale is complete, the lender may not pursue a deficiency judgment on qualifying residential property that falls under the anti-deficiency statute, as discussed in Module 11.1. This ensures homeowners are not burdened by remaining debt after losing their property through foreclosure. For real estate licensees, understanding this process is essential for assisting clients in distress. Agents should explain general timelines and requirements, but refrain from offering legal advice about foreclosure rights or procedures. Under Commissioner's Rule R428-1101B, licensees must act competently and refer clients to attorneys for legal interpretation. They may, however, help homeowners explore alternatives such as short sales or loan reinstatement to avoid foreclosure. Discussion. Why does Arizona use the deed of trust foreclosure process more frequently than judicial foreclosure? Answer. Because it allows lenders to foreclose without court involvement, making the process faster and less expensive. What is the minimum time between the recording of the notice of trustee's sale and the actual sale date? Answer. 91 days, ensuring borrowers and lien holders receive adequate notice. What must occur for a borrower to stop a trustee's sale before the auction date? Answer. The borrower must reinstate the loan by paying all overdue amounts, late fees, and costs before the sale. Review summary. The deed of trust foreclosure process in Arizona provides a streamlined, non-judicial method for lenders to recover properties when borrowers default. The process begins with the recording of a notice of trustee's sale and ends with the trustee's public auction, after which title immediately transfers to the purchaser. Borrowers have the right to reinstate their loan before the sale, but have no redemption period afterward. Compliance with statutory procedures, including proper notice and publication, is critical to ensure a valid foreclosure. Real estate professionals should understand this process, educate clients about general timelines, and always refer homeowners to legal counsel for advice on rights, reinstatement, or deficiency protections.